Hi, everyone. Welcome to our new episode of the Downsizing Coach and Downsizing Your Home and Life Radio. Wonderful to have Lindsey Sarowitz here with us on regarding Estate Planning 101. Thank you for being here, Lindsey.
Thank you for having me.
Lindsey is an incredible associate at Handler and Levine LLC. They're located in Washington, D.C. She's a member of the Maryland Bar Association, Virginia, as well as District of Columbia, and practices regularly in all three jurisdictions. As part of her practice, she holds very wonderful seminars for federal government employees through the National Institute of Transition Planning, and she's also an adjunct professor at Montgomery College. Congratulations to you. That's wonderful accolades. And she also teaches wills and estates as well as probate in Maryland. Thank you so much, Lindsey, for being here with us today.
Thank you again for having me.
Absolutely. We're gonna jump in. You're like a wealth of knowledge and information. I think it's been over 7 months we've been trying to get this show for us to put a time together for your busy schedule to be able to be a guest with us today. And I would love for you to start us off and share with us, what is estate planning?
Yeah, I guess that's the best place to start, the most basic question that I can answer. So estate planning is basically planning for the time you pass, right? At a time that you are alive and well.
Right.
That's kind of how a lot of people think about it, but it's also planning for potential incapacity. So basically, setting up who you want to be in charge of your assets, your medical care, everything like that, not just, in the short term, but potentially in the long term as well. So if you become incapacitated, or then eventually if you pass away, or when you pass away, I guess is a better way of putting it. So I'd say a typical estate plan, and we'll go into all of this today, would include a power of attorney for financial and legal matters,
Right.
a healthcare directive for medical issues, a last will and testament. So that's where you say what you want to happen to your stuff at your death. That's a very basic way of putting it. Potentially a revocable living trust. And then always making sure that the beneficiary designations for all of your beneficiary designated assets, like retirement, life insurance, are all set up. As well as guidance with regard to jointly owned assets. So I feel like a comprehensive estate plan needs to have an element of all of those. For example, if your beneficiary designations don't need to be updated, that's okay, but it should be a conversation, if that makes sense.
Absolutely. So I wanted to see, why is estate planning important for myself and for our listeners?
Sure. So a lot of people think that estate planning is only for wealthy people, only for people with children. I've heard it all, why people haven't done their planning or why they think they don't need an estate plan. But I'm here to tell you that everyone does. So even if you are not wealthy, whatever that term means to you, right? It's a very subjective term. Even if you have no property to dispose of at all, everyone needs, at the very least, from the time they turn 18 until the time they pass away, a power of attorney and a medical directive. Without these documents,
Lindsey, that is so critically important. I'm sorry, I'm just going to interject here for our listeners, that those two elements are so easy to obtain and so easy for them to put into place, and to have multiple copies of these documents, and to have their attorney help them, or yourself help them prepare these important documents that they can keep for years to come.
Absolutely. Yeah. Without them, the power of attorney for finances, absolutely, a financial institution is not going to take someone's word for it, that they're the right person, that they're who you wanted to handle your assets. And similarly, even doctors, they don't have to listen to your loved one if you become incapacitated, which we'll dive into a little deeper, but doctors don't have to, and financial institutions won't listen to your people if you don't have these documents. So, a lot of factors impact what documents are needed and what's appropriate for you. So there's very few things that I can say everybody needs this or everybody needs that or everyone can expect this or that. So when I say that everyone needs at least the power of attorney and healthcare directive, that's not something that that I say with regard to a lot of things. So a lot of factors are going to impact what plan is appropriate for the individual, right? Besides wealth, right? Wealth is one factor for sure. But others might be, if you care for a minor or a disabled child. If you are concerned about incapacity planning, so planning for your own incapacity, caring for your surviving spouse, transferring assets in accordance with what you want, not what your state says it's going to be. And then sometimes people want to avoid probate depending on a lot of factors. And, if charitable giving is something you're interested in. So again, there's a lot of different factors that should be discussed with your attorney, but step one would be the power of attorney and healthcare directive.
Yeah, and I really love the fact that you bring to our attention the fact that this is important not only for us as parents, but also for our children that are over 18. And I thought that was a very interesting point that you brought up during our conversation, that it's important because unfortunately things happen unexpectedly, accidents happen, things that none of us are cognizant or anticipate. But it's very important to have these things in place, one for the financial and one for the health, because it really empowers you at a time of need and spares you the mental anguish, the anxiety, as well as the financial aspect of trying to gain control of a situation that is, emotionally difficult.
Very well said. I agree.
So let's talk about what is the power of attorney and why do I need one even if I'm married?
Good question. So the power of attorney, first off, it's one of the documents that I refer to as a lifetime document. So the power of attorney, the healthcare directive is the other, which we'll talk about shortly, but the main reason or the only reason we refer to this as a lifetime document is because it's good and it's valid while you are alive, but it dies with you. So just at the outset, I want to, mention that when I get a call from someone saying, hey, my mom died last month, I've still been paying her bills and managing her assets as her power of attorney. I got to say, stop right there. You might still have the ability, you might be the right person under her will or her trust or what have you,
Right.
But your power of attorney hat is no longer the hat that you're going to wear after someone passes away. So the power of attorney document essentially allows you to name someone, whoever you want, right, to act for you with regard to your legal and financial matters. So a lot of times people think that if they're married, like you mentioned, they don't need a power of attorney. They think that just because they're married, their spouse can do anything for them that they would have wanted them to do. Right. My guess is with your background, you already know that this isn't true, right? Like, for example, if spouses are selling their home, right, they're both on the deed. Well, they both sign the new deed to transfer ownership to the new owners, right? If one is traveling or one is not there at the time that deed is signed, you don't just say, okay, wife, you can sign both names or you can sign for your husband. No, either both of them are there, or in that scenario I just mentioned, the wife needs to have a power of attorney for the husband. So, it does come as a surprise to a lot of people that, yes, your spouse will be able to access joint assets. They certainly will not be able to deal with individual assets. And remember, retirement is always in one spouse's name, right? So I have clients that fill out our questionnaire and put their 401k as a joint joint asset, and that's sweet, but it's not legally, the way it is. So, right. So, and then they are very surprised that the joint owner, the spouse, can't sell the property on their own, can't mortgage it, and things like that without them. So,
And I mean, it takes time. If any of these preparations are not in place and someone experiences any of these, I mean, just the panic that I hear in clients' voices when they call and they do not have a document in place when someone is either incapacitated or something more tragic has happened. It's an overwhelming emotional toll, and sometimes they're not able to make the best decision that they would have during a time when they were not under duress. So it's really advisable for couples and for families to really sit down and talk and to have that dialogue with amongst themselves and then with their professional counsel in order to be prepared and to have that peace of mind. If anything was to happen, that, it's going to be okay. And I think that's really the objective that I have, is to, for the purpose of our podcast and our radio show, is to get the information out and to make it so seamless so that individuals are prepared not only for themselves, but their parents, their spouse, their children. So if anything unforeseeable does happen, they are prepared.
yes, definitely. And what you said was so true. People usually don't make the best decisions when they're under a ton of stress and that tight timeline. So why not do it now, before you need it? That's absolutely kind of the purpose of all these documents, right?
Absolutely. And that leads us into the question, what will happen then if I do not have a power of attorney and I become incapacitated?
Sure. So if you do become incapacitated and don't have this document, right, the power of attorney for legal and financial matters,
Right.
what will have to happen for someone to access your bank accounts and use your money to pay your bills and so on and so forth is someone is going to have to go to court. Now, when I say the word someone, keep in mind, who's that someone going to be, right? Is it going to be this someone that you would have wanted? Or is it going to be, do you have 3 adult children and one of them you really would not, you love them, but you wouldn't want them in charge of your money, but they happen to be, kind of the one that the other kids don't really fight back against, for example. I'm just making that up, but then that child might be the one that goes to court and asks for what's called a guardianship, or in certain jurisdictions, it's called a conservatorship for someone over the age of 18, but we'll just refer to it as a guardianship. So that someone goes to court, asks the judge to appoint them as guardian. Now, keeping in mind that typically that person would hire an attorney to prepare the petition for guardianship. Now, as we're talking, if you see dollar signs when I say the word attorney, I will not be insulted, right? We know that attorneys charge for our time, and our time typically doesn't come cheap. So that person's going to hire an attorney, go in front of a judge, ask to become the guardian. Another attorney will be appointed for the allegedly incapacitated person, kind of as their mouthpiece. Right. And the judge will typically send an investigator out to determine whether that person does in fact need help. Is mom actually incapacitated and needs this child to help her? Or is mom totally lucid, but wanting to give her whole estate away to charity? And so that child is trying to jump in and stop that from happening, right? So, so that is typically a very expensive and time-consuming process, even if the whole family is in agreement. That would be called an uncontested guardianship. Now, if the family is fighting or disagreeing in any way, all bets are off. For a contested guardianship, it'll be even more expensive and more time consuming. So that's why, to avoid all this. Oh, go ahead.
I'm sorry. Yeah. Finances, you're absolutely right, is one aspect of it. But when you enter the court of law, you're working on the court schedule. And unfortunately, when things have to go in front of a judge, it can take time when it's important in a critical moment to make some decisions and for things to happen. You want to be proactive in this, and you want to avoid all of these bad what ifs, and make sure that your ducks
Right.
are lined up to your wanting. Have the individuals that you would like to be in charge of your finances, in charge of the paperwork. Maybe you want to delegate different responsibilities to different individuals. I've seen a ton of times where parents are like, my middle child is far better at the health aspect of making decisions, and we want the older child to perhaps be responsible for our financial component of our estate. So you have that opportunity to make those decisions and to think about and to have the conversation. Perhaps you want to have an earlier conversation with your adult children, in advance, and prepare them and let them know what your wishes are. Either case, it allows you the opportunity to be prepared, to think about what the best decisions are for you and your family, and really protect your kids from being torn into this situation where they have to take time off from work or fly in to be in the local city. I mean, it gets complicated and expensive.
Definitely. Yes, well said.
Yeah. So this leads us to our next question. I've heard there are different types of financial powers of attorneys. Is this true?
Yes, so there's a lot of different types of powers of attorney
Mhm.
based on where you live
Right.
and whether you want your agent to have very broad powers, that would be called a general power of attorney, or whether you want some limitations, that's called a limited power of attorney. That kind of makes sense. But as far as the general power of attorney, I'd say that's typically the type of power of attorney we're talking about, right? Like saying someone to take control if necessary at the time that that's needed. And I do want to say that calling it a general power of attorney is really aspirational, to be honest. You can never have a one-page power of attorney document, for example, that says, I want my agent to be able to do everything I could do, sign, notarize, done, right? You actually have to list out every single power that you want your agent to have. So it's really important to think about all those things that you probably wouldn't think about, right? So I think of this as like a toolbox for my clients, right? So we put all of these tools in the toolbox, and if their agent doesn't need one of the tools, it's just a little extra ink on a piece of paper, right? But if the opposite happens and one of those tools isn't in the toolbox, again, we go back to going to court and getting some sort of order allowing them to act with regard to that asset that wasn't included. So, it's really important to keep in mind what you want your agent to be able to do,
Right.
as well as whether anyone else relies on you.
Right.
So, for example, if you help your mom pay her rent every month, right? Or maybe you have a child that's technically an adult but hasn't fully launched into the world, and you're still paying their health insurance or something like that. If you become incapacitated, unless it's written there that your agent can use your money for someone else, they can't. So you need to put that in there.
Right. And I mean, really, I think with COVID and with everything else going on, it's really given us a sense of reality as to how things can sometimes unexpectedly go wrong because of health issues and prolonged periods of time that people might be ill or in ICU or have complications, right? Where if your finances are not delegated, no one's going to be able to pay your mortgage. So things can quickly change. Like if you come out of an illness unexpectedly, if you don't have these things in place, like your credit could be affected. There's going to be other complications. You've created anxiety for your family members. So again, preparedness, having the conversation, all work in your benefit the way that you want it to be done and spelled out such. So our client, our a lot of individuals would ask, who should I name as my agent?
Yes, that's a really important thing to consider, right? Not just, oh, I need this document, but one of the reasons I think that people maybe put off doing these documents is because they're not sure who their name, or they're uncomfortable giving someone so much power, right?
Okay.
So if you're married, for instance, a logical first choice might be hopefully your spouse, right? For those people, the real question is who to name as the backup. Maybe they have one adult child, and that's a logical backup, right? Because you always want to have a primary as well as at least one backup. I love it when clients have a whole bunch, right? But I'd say that issues come up a lot when someone isn't married, doesn't have adult children, or doesn't have much confidence in their adult children, right? So when helping clients like that decide who to name,
Right.
we typically advise that they look to two characteristics. One is trust, right? You're giving someone a lot of access and control, the power to change your estate plan, the power to access your accounts, the power to sell your real estate if necessary, the power to update beneficiary designations, right? We need to trust that person we're naming. And the second is common sense. And that's where a lot of people's lists go down, right? There are a lot of people they trust, and then they're like, oh no, does that person have common sense? But what I mean by common sense is you don't need to name an attorney or a CPA or a financial advisor, right? You can name someone who doesn't have any sort of specialized knowledge. They just need to have the common sense to know, okay, I don't really know how to do that task. I won't need to hire someone, right? They don't need to figure out how to file your tax return. They can send the documents to the CPA, but they have to have that click in their mind that says, oh, wait, I need help with that, right? And they can use your money to assist them as is appropriate. But again, they don't need that specialized knowledge.
That's a great point. Common sense, right? That's what we hope. So that leads us to a great point. What if someone has two children? Should they name both children?
I get that question a lot. Now, you can name multiple agents to act together. You absolutely can. But I always make sure to have a pretty deep conversation with my clients about that, if that's what they're thinking. A few things to remember, think about how those two adult children, for instance, get along today. And keep in mind that, like you said earlier, this is going to be a time of enormous stress. It's, for lack of a better word, a burden, right, to have to take care of parents. I mean, it's true. People aren't typically their best selves when they're under that stress. So also think about what their work styles are. If you have one child that gets all the bills paid early and the other one's constantly begging for forgiveness on late fees, right? Putting those two together to act together might just be setting them up for disagreement. And don't just think about short term, because it's possible, we see it, that someone's incapacitated for years, right? So we want to keep in mind that if you name two people to act together, they potentially may need to act together for many years.
Right. And Lindsey, you brought up a great point. I mean, and a consideration for everyone to make. The document you're preparing today, let's say somebody's in their 60s and they're preparing this document. This document for very well could live for 20, 25 years, right? So you want to have the foresight to kind of think ahead of, or someone might think, I'm healthy today. But when you're thinking about preparing this document, not only do you want to think about, where you are today, where you're going to be in 5 years, 10 years, and 20 years as you prepare this document. And to have that foresight and to really write down what your wishes are. And I think I get a lot of phone calls and I hear a lot of stories from families where they say, I wish I knew what my parent wanted. And the problem is that they might have some of these documents in place, but they were not spelled out, or they did not have a conversation earlier on with their children about what they might like to see happen in certain cases of these scenarios. So it's important again to think about what, how they want these documents prepared, but also have that conversation and prepare the loved ones that you're entrusting to be your advocate, to do the things that you want them to do for you.
Absolutely. And that just brings up one thing that I, always tell my clients, which is, yes, what you said is absolutely true. So some people will do their documents today and not update them. Okay. Right. So that just happens. Some people think of this as a set it and forget it type of thing. I urge people not to think of it like that, right? So I tell clients to look at their documents every 2 to 3 years, make sure they still make sense to them. And right. Then sit down with me every 5 years or so for like a checkup, right? And because you know what changes happen in your life. Right. I know what changes happen in the law. And unless we sit down together, we don't really see the other side of it. But it's also important to keep in mind that if you set up a, in your scenario that you just laid out, the 60-year-old setting up their estate plan, there is the potential that they may become incapacitated between now and 5 years from now when they're going to do an update. So then, like you said, it could last them 20 years of incapacity, which would be pretty tragic anyway. But certainly making sure you name the right people for the long term, just in case, is really essential.
And that's why speaking to the right professional who's going to be able to guide you in that is priceless, really. It really is priceless. And that really leads us again into the conversation with the healthcare directive. Let's, what is that exactly? If you can define a healthcare directive for our listeners, that would be phenomenal.
Absolutely. So, first, I want to say that this document comes in a lot of different names, right? So depending on where you live, there's different names. Some places it's called an advanced healthcare directive. Sometimes it's called a living will, or a medical directive, or a power of attorney for healthcare. There's plenty of names for it. But this document, whatever it's called, needs to do a few essential things. And please note, I've seen them where they don't do all of these things. And that's kind of a disservice to your family. And I'll tell you what I mean by that. So first, you need to name who you want to act for you, to take control and make your medical decisions if you're unable to do so yourself. So that's number one. I've seen healthcare directives, very rarely, but I've seen it, where they stopped there. They didn't fill out the rest of the state form, right? They named someone to act for them, but gave absolutely no guidance, kind of like you were saying just before, as to what they wanted to happen. So that's pretty terrible, right? Naming your child, but not saying what you want. So they need to say who you want to be in charge, as well as what your specific wishes are. If you're in a certain condition, you can also say if you want to give anyone else access, but not control, right? To your medical records, to speak to your doctors, that's called HIPAA authority. As well as if you want to be an organ donor, all sorts of things we can add in there. But those are some essential things that you need to put in there.
Mm-hmm. Those are all critically important. And I always, again, another element that I always remind everyone, as they're getting these documents prepared, have your attorneys create multiple original copies for you. And the reason is if you're traveling, I always ask people to have, copies, or if necessary, if you have 2 homes, people have Florida homes, or they might have more than one property, they can have the original on site. Because I've seen institutions say that they're not going to take a copy of a document and insist on seeing an original sometimes. So it's important to have the right documents in the right places and to have access to these and to distribute these copies to the individuals, so that it actually happened to a friend of mine. Her husband had an unexpected stroke. He knew where the documents are. She was in the hospital. While he was in the hospital, his father also became ill, and her husband was the one responsible for his father. So
Oh,
she did not know where those legal documents were. So she literally had to leave his bedside to go home and to dig through where she thought these documents were. It could have been at the house, or she didn't know if it was in his car, in his office. So it's important to document. And unfortunately, unforeseen tragic things happen in multiples that people don't think about. But I think we're here to tell you, we hear so many endless stories. And that's why being prepared on different levels will protect you, your family, and your loved ones. So that
well,
really,
that brings up a good point. Oh, sorry.
so
I
go
was
ahead.
just going to say that, I was just going to say when I talk to my clients, I always make sure that I provide them with multiple copies and tell them that the healthcare directive specifically must, and I mean must, be given copies because uh, the doctors, will take that. So it must be given to everyone listed in the document. And I also advise them to give copies to their primary care physician. In fact, I recently saw on they all have the patient portals these
Right,
days.
right.
And I recently was on my doctor's patient portal and I saw a button, upload your documents.
You're
And
right.
so that would be, mhm. And so for your friend, if the doctor already had the father-in-law's documents there, she wouldn't have had to rush around. But who would know that unless someone told you, right? It's like so unfathomable that she went through that.
It's it's
So
it's it's
yeah,
tragic, and for everyone involved, when something goes wrong, I'm here to tell you. Unfortunately, it's emotional. It's just a toll on everyone. But it really takes us into, again, if you're married, do I need these documents? And I think we kind of covered it. But again, we want to drive this point home that even if you're
right,
married,
right.
Lindsay,
Yeah. So yes, I mean, so listen, I always, when I give seminars, when I talk to clients, there's always somebody that says, well, I was able to act for my mother. I was able to act for my spouse. I'm not saying that that's not true, right? So banks, forget it. They will not listen to you if you don't have the document. But with healthcare, um, you know, there is such a thing as a verbal healthcare directive. And we actually saw this, if you remember the Terry Schiavo case years ago.
Mhm.
So doctors were listening to her husband for years. But then as soon as another credible person in her life, it was her parents, came forward and said, no, that's not what she wanted. The doctors threw their hands up and they said, you guys fight it out in court. And that was a battle. That was a real litigation. And I think, don't quote me on this, but I think they actually withdrew life sustaining procedures and then put her back on life support before eventually taking her off. So, like, what an awful situation for her entire family, because again, verbal directives are valid. So doctors may say, okay, you're the spouse, we'll listen to you, but they're impossible to prove. And who knows? Maybe the doctor just got sued last year because they listened to the wrong person. You think that doctor's going to do that again? I don't, right? They'll require documentation from there on out. So it's very important to have it in writing.
Right. You're absolutely right. And again, back to the medical directive. Um, I had a question for you in regards to what does the healthcare agent do?
Yeah, so a lot of people, most people, I would say, think of this as end of life, right? Do I want life sustaining procedures given or do I want them withdrawn? Half the time, when I ask clients, in a consult, I'll say, if you're in a persistent vegetative state, do you want life sustaining procedures given or withdrawn? Half the time, they'll interrupt me in the middle of my sentence and they'll say, pull the plug, right? That's like the common term for it. But that's not all your agent's going to have to do. Again, we don't have a crystal ball, right? This document may never come into play. Maybe you'll pass away peacefully in your sleep at 100 years old, but maybe not. So, so this person is not just going to make those decisions. They're also going to make day-to-day decisions, and they're going to have to be your healthcare advocate. You're going to want to name someone who has the ability to, you know, not just listen to the doctors. If something doesn't make sense, if they think that you're not getting the proper care, you know, they need to have that backbone to say, no, move my mother to another facility or give my mother another doctor.
That is a great point. But they need that legal document in order to be able to do a lot of these things. And you bring such an incredible, important point that this happens all the time. The right, you know, you're traveling and you have an accident. So you're in a small little town hospital and you need major help for, you know, and you want to go to the regional hospital, right? In order to do a lot of these things and to make them happen quickly, somebody needs to have legal authority to make those things happen for you efficiently, cost effectively, and quickly. So that's an incredibly important point, Lindsey, that you bring up. Now, how is, what else does a directive say? You know, what is a DNR? You know, can you talk to us a little bit about those points?
Absolutely. One great thing about medical directives is you can really mold them to your desires, right? So we always talk to our clients about what their wishes are, and you know, outside of what the, you know, state form, so because many states have a form directive, but they don't ask the same questions, you know, obviously a human with years of experience would. So
Right.
we ask clients what's important to them. So we can often say, you know, if you want to receive medication to ease your pain, even if it hastens the moment of your death, right? I know that's in my document. We'll often also say if someone has family that maybe they are out of town, you know, maybe they live far away, or maybe they travel sometimes. Most people, you know, absent COVID, it's not unusual to have family traveling at the time of an accident. So oftentimes, even if someone wants, you know, to be let go, if they're in a certain condition, will say that they would like to be kept alive for a period not to exceed 3 days or 5 days, whatever it may be, so that their family, their immediate family, can come say goodbye, right? Because you don't want to, if you have a child living in, I don't know, Israel, right? They can't just hop on a plane like the person from New York can to come down and see you. So you might want to extend that because most likely, right, this is a conversation we have with our clients, but most likely you don't want to be let go when that child has finally arrived at the hospital, you know, been through all that to get there, and then you're let go when they're on their way up in the elevator, right? So that's an example of something we might do. And, you know, we also might say, and this is very helpful for a lot of people, and I know I mentioned it briefly before, but if you want anyone else consulted or anyone else to have HIPAA authority or ability to talk to your doctors, because a lot of times we'll have clients, again, you don't need someone with specialized knowledge, right? You don't have to go searching for a doctor or a nurse that'll serve for you. But if you have, you know, your adult child listed, and then maybe your sibling happens to be a doctor or happens to have a medical background. So if that agent, your child in this example, is saying, Aunt so-and-so, this is what the doctor said, and she's like, that doesn't make any sense, you know, do you want this game of telephone to continue? Or do you want your sister who is in the medical field to be able to call the doctor, see your records, be of assistance to your child in making those decisions? So that's one thing that a lot of people do want.
Incredible.
Yeah.
There's so many connect the dot versions and possibilities that it's amazing. It really is, Lindsay, to hear you demonstrate and illustrate for us different potential ways of thinking about, areas that a lot of us may not have considered. So this is very, very helpful information. And I think it really leads us to the most important element that everyone's familiar with, but I think you have a lot of words of wisdom to talk to us about wills. What is a will? What are the elements of a will, and so forth? And what happens if someone?
Sure. I did realize. Yeah. I did realize I didn't get to your follow-up question that I
Apologies.
realized I heard it. I'm so sorry. So no, that was my fault. So you asked me whether what a DNR is. So I just want to touch on that before we move on, because that was a good thing that you brought up, because a lot of people get confused when I'm talking about the medical directive and think I'm talking about a DNR. So a DNR is a do not resuscitate order. It's done with your doctor, not with your lawyer. And basically what it says is, if I'm found in need of resuscitation, I don't want the EMTs to help me. I want them to let me go, right? So people typically would only have that if maybe they're older or maybe they've been ill for a long time, right? I know if I'm in an accident, I want them to do anything they can do to bring me back, right? But basically, unless you have a DNR, and note that it has to be in a place where the EMTs see it, there's no such thing as a verbal DNR. So unless you have one, basically the way that these two documents work together, or don't, would be without a DNR, the EMTs would save your life if they can, bring you to a hospital, and once you are stable, that's when the healthcare directive would come into play. And then also in the healthcare directive that we do, typically we will say that your agent has the ability to sign a DNR for you. So that's where that whole thing comes together, because if you're incapacitated, you've been brought back a bunch, and your agent knows you wouldn't want that anymore, well, you can't sign the DNR because you're incapacitated. So that's kind of how that works. Does that make sense?
It does. So can you clarify? So in that directive, you cannot specifically state, even though it's not the instrument that is used, that you do not want a DNR? And it only can be placed in the document between the medical provider and the patient?
Well, so you don't have it. You said that you do not want a DNR.
If somebody did not want a DNR, you're saying that they cannot put it in their medical directive? You just indicated that they can give that permission for the agent to make that decision. But can they also still state in the medical directive that they do not want a DNR?
So you do not have a DNR unless you have, like, it's not something that you would say, I do not want one, a do not resuscitate order. It's like you don't have one unless you take that step to do a DNR with your doctor. So when I said that in a typical medical directive, you would allow your agent to sign a DNR for you if something were to happen. If you don't want your agent to be able to sign a DNR, you would simply remove that power from there.
Okay.
So that's kind of how that works. Yeah.
Great. So that leads us into the wills, and how does the will and the elements of the will and members of the will and so forth benefit?
Sure. So yeah, that was, like I said, that was my fault that I skipped over that question. But so the will is another very important estate planning document. And I think when people think about estate planning, quite honestly, this is what they're thinking about, right? They're typically not thinking about the lifetime documents that are equally as important, and hopefully that's been clear. But they're thinking about what happens when I pass away. So your will is a document that would say exactly that. You would appoint who your personal representative or executor would be, and those terms are interchangeable. And again, common sense and trust, right? Those are those two characteristics for any fiduciary. And you're going to state in that document how you want your assets to be distributed at your death. You can also, if you have minor children, this would also be the document where you name guardians for your minor children. Note that I've seen a lot that is one of the sticking points between spouses, and a reason that people choose not to choose, right? They decide not to do their documents because they can't, them and their spouse can't decide on one person. So please don't do that if anyone's listening, right? But in this document as well, you would do, I don't know if you've heard the term testamentary trust, but a testamentary trust is a trust that springs into existence at your death. So it's not a trust that's created today, unlike a revocable living trust, which we can talk about in a couple of minutes if there's time. But it's a document that you put in your will or your revocable living trust that springs to existence at your death if certain conditions are met. So there's a lot of different ones you can do. You can do marital trust for a spouse, parental trust for a parent, so on and so forth. But the one that we do, I'd say the most often, is trust for children. So if you have a minor child, it's important to know that they can't inherit. They cannot control money. They can't inherit from you outright. So without certain planning, bad difficult things are going to happen.
Bad things happen. I'll say it for you.
Bad things happen. I know, right? So, and then also remember that people may have technically adult children that for one reason or another should not inherit, right? So minors cannot inherit. Certain adults should not inherit, and that might be because they are an adult in the eyes of the law, but you as their parent know that they are not ready to handle potentially millions of dollars, right? Or maybe they have a drug or alcohol issue, or maybe other special needs where leaving them money can really literally hurt them. So what we do there is we create a special type of testamentary trust. So in like a typical minor's trust that we might do, we might say, if the kids are pretty young, so we don't really know them yet. I'm sure they're the best 5-year-old that's ever walked the earth, but who knows what they'll be when they grow up. So we might do like 35 or 40-year trust terms, and we might say, the trustee, so that's the person who's in charge of the money for that child, can use money at any time for that child's health, education, maintenance, and support. And then the document itself will say when the child can get money to do whatever they want with it. So we might say 5% at age 22, 10% at age 25, 25% at age 30, and the remainder at age 35. We also give that trustee, the person who's seeing what's going on in your kids' lives, how they're doing after you're gone, a lot of discretion. So they can give larger distributions sooner for a worthy objective, like down payment on a home, acquiring a business, things like that. Or on the other side, they can withhold distributions if they see something that worries them, like drug or alcohol use, creditor issues, a divorce is in the, pending, things like that. So it's really important to remember that, one, who are your beneficiaries, right? Who do you want to inherit and how? And then two, just doing this document isn't enough. You actually have to make sure you designate the trust as the beneficiary on your beneficiary designated assets.
Right.
So
amazing. That's a lot of content right there. But we're gonna flip the page, and that's the great scenario of being prepared. And we're gonna talk about the ugly that, unfortunately, as an appraiser, I get called in way too many times. What bad things happen if you don't have a will?
Mm-hmm. So if you don't have a will, that's called dying intestate. Um, just a little phrase, little Jeopardy phrase. um, but so if you die intestate or without a will, basically instead of you saying who's going to be guardian of your minor children, how your children will inherit. So, your child might have special needs and things like that. So you create that trust or whatever. And who's going to be the personal representative of your estate. That's all going to be determined by state law. So all of your kids will be treated equally, even if they shouldn't. Stepkids will be completely excluded, even if you've been in their life since they were babies. And also, the intestacy laws with regard to distribution of your assets are often not what the client actually wants. So a lot of times will have people attend my seminars that think, well, I don't need a will because I want my spouse to get everything and that's what's going to happen. Well, they're wrong. At least in Maryland, if you die without a will and you have a spouse and children, your estate will be split between them, not 50-50, but in some proportion. So the vast majority of people, in my experience, don't want that. They want the spouse to get everything and then the kids to get everything at the spouse's death. So that's kind of, a lot of stuff will be, or everything really will be out of your control and just left up to the state laws.
Right. And if and if those bad things happen, right, and someone does not have a will in place, explain to us what probate is.
Oh, sure. So, well, that brings up a good point. So having a will or not having a will does not create probate. So a will is simply a set of instructions of what happens in the probate process. So unless you do something to avoid probate, there will be a probate regardless of whether there's a will. So probate is, at its simplest definition, I'd say, or the simplest one I could come up with, it's the court supervised process that identifies what probate assets, I'll define that in a second, the decedent owned at death, and oversees distribution of those assets, either according to will or the laws of intestacy, what we just talked about. So in that definition, we need to know what probate assets are. So I know that when you own real estate or accounts or anything joint with rights of survivorship, or tenants by the entireties, which is joint with rights of survivorship among spouses. As soon as the first joint tenant dies, it passes automatically to the survivor. So that is not a probate asset. Probate assets are assets titled in your name alone with no joint with rights of survivorship ownership and with no beneficiary designation. So the 401k that you have designated your spouse on, not going to go through probate, for example. So probate assets go through probate, non-probate assets don't.
Excellent clarification. Thank you.
Sure.
So it sounds like a lot of work, right? Probate has a lot of steps. It's a lot of work for the administrator of that of the case. How is it avoidable, and what steps can people take to navigate this ahead of time?
Yeah, so probate is avoidable. Whether or not it makes sense in a certain scenario to avoid it depends on a lot of different factors. So I will say some ways that probate can be avoided would be owning property joint with rights of survivorship, like I just said. But for anyone listening, please don't rush out and add your child to your real estate or your accounts. Like, I very much advise, I can't emphasize it enough, that people get guidance before putting someone else on their assets. There's a lot of downfalls. You're going to subject your asset to your children's creditors or whoever you're naming as joint owner. You're going to do all these, I could go on and on, but I'll spare you. But basically, you don't want to jump to that step. It's very easy to put a joint owner on an account or a piece of real estate. It's much harder to get them off. So you want to make sure you talk that through and think that through. Another way is, beneficiary designations. Like I said, certain assets can be beneficiary designated, like life insurance, retirement. And basically what happens there is the person designated as the beneficiary will send a claim form and get the life insurance check or get access to that IRA or whatever that may be. There's also the ability with certain accounts to do a payable on death or transfer on death. That's POD or TOD. It's often referred to as designation. Now, unlike joint ownership, when it comes to payable on death, transfer on death, you can name multiple people to get that asset at your death. It is revocable. You can say who gets what percentage, right? And you're not subjecting that asset to the creditors of your beneficiaries while you're alive. Another way is through gifting. This is another thing. Please don't run out and give away all your assets, right? You need to have a discussion with an attorney or a CPA with regard to whether gifting is appropriate.
Yes.
Right, exactly. Because definitely, I've seen people create a huge capital gains tax issue for their family because they were just trying to avoid probate, because you get a full step up in basis as of the date of death if you inherit property, and not if you give it away. So just anytime someone's thinking about giving away or receiving an appreciated asset, I just tell them, wait a sec, talk to a CPA, talk to an attorney, talk to someone first. Aside from all those things, another way is to create a revocable living trust, which I'm sure you've heard of.
Yeah.
So unlike the testamentary trust that I mentioned earlier, a revocable living trust is an entity in and of itself. So when we create it, it is a separate entity. Now, it doesn't get a separate EIN, employer identification number, until you've passed away. It uses your same social security number. You still have the same access to the accounts and money and everything like that. But basically, you create this trust. And my definition of probate assets, assets titled in your name alone. Well, now you're going to move assets from your name alone into the name of your revocable living trust. Mm-hmm. So that is what gets it outside of the realm of probate. So it's not just enough to create the trust. You have to properly fund it or move assets over. Does that?
Title, absolutely. And I'm going to give an explanation to our listeners. A lot of you perhaps have seen on real estate title, it may not have the individual residence or the owner's name on there. It might have the name of the trust because the asset is allocated in the trust, and therefore the paperwork, the title, it reflects the name of the owner, which would technically be the trust, even though the individual owns the trust. So it's a great opportunity for a lot of multiple, a lot of clients love using it. And it's a great opportunity for you to have the conversation, look at asset protection, look at avoiding a lot of these things from happening with all of these different options that are available to you.
Right. And yes, and like you said, look at it, right? Because whether a revocable living trust makes sense for someone, it really comes down to an analysis of a lot of different things, right. Where they live, whether they have multiple pieces of real estate in multiple jurisdictions, because avoiding multiple probates is even better than avoiding one probate, right? And certain probate proceedings, like in Maryland, probate is pretty straightforward. I'm twice as likely to recommend a revocable living trust-based plan to my Virginia clients than I am to my Maryland clients. So there's a lot of factors to consider. And I've seen before, people that will say everybody needs a trust, right? I don't say that. I don't even know who the listeners are today, right? I would need to have that conversation and help them decide kind of what makes sense to them, what's important to them, because that's really what needs to guide this, in my opinion.
Exactly, where their residency is and where they're located at all, because every state has different rules, regulations, and probate laws. Absolutely. So can you tell our audience a little bit about the estate planning process and what they should expect if they have not began any of these processes yet?
Absolutely. So I know that this is kind of why a lot of people attend my seminars, and I can tell that because when I start the seminar off, people start raising their hands, or now when we're doing it remotely, they start typing in the Q&A, how much can I expect to pay, or how do I find an attorney, from the second I open my mouth. So for most people, the estate planning process starts with looking for an attorney, right? I don't know anyone. Where should I go to figure that out? I mean, I happen to know a great attorney here locally, but where can you find one, right? So a few things to consider. Now, I know that I personally do go online to look at, good places to go to get my nails done or get my hair done or whatever. I don't stop there though, right? I read the reviews, I read things beyond. And so I think if you're looking online for an attorney to help you with this,
right,
keep in mind that the website design company doesn't look at our resume. They don't see how many estate plans we've done. They just care if we've paid their bill, right? So you can look online, but maybe that might not be the end answer. In my opinion, the very best way would be to talk to people, right? Talk to local people, maybe colleagues, friends, family members that are local, see who they used, see what the process was like for them.
right.
So, I mean, I think that that's the best way really to find anyone. I mean, my mechanic is the one that my colleague uses and has used for years. And that was enough of a referral for me, right? If they're good enough for her, they're good enough for me. So, and then there are some attorney review websites. One is called AVVO, AVVO, that's V as in Victor. And I don't know if you've heard of it. A lot of people haven't. But there are, that's an opportunity that clients have to go on, review their attorney, and kind of say what they thought about the process. Now, so far in my practice, I haven't, as far as I know, had a client that wasn't satisfied with my services. But I will tell you, if I did, I wouldn't tell them about AVVO. I wouldn't say, hey, please write me a review, right? So unless someone happens to know about it, the attorney's probably the one that told them to write them a review. So just also take that with a grain of salt, right?
And there are an overwhelming amount of reviews in comparison to the other social media platforms, even though it's an excellent resource that you bring up. But I do want to interject with something important for people to think about this in an analogical way, as you said. If you have a Maserati, right, you're not going to take it to a general mechanic. Hopefully you're not going to. Or if you have a German car or specialized vehicle, right, you always try to take it to the person that is specialized in dealing with that type of car so that they can perform the best service for you and with the least amount of pain, figure out what's wrong with the car and help you get it resolved. And because that's all they deal with is that type of car. It's the same thing with law. And I would always encourage individuals, if you're going to someone who does divorce and who does immigration and who does probate and who does a little bit of everything, they're not going to be as specialized as someone who generally specializes in probate and wills and estates and trusts and so forth. So ask a few questions, see, ask around and get the person that would best fit your needs for whatever type of legal law advice you're looking for. I always recommend to go to the most expert in that niche that you're looking for to get the person with the most relevant up-to-date information, because tax laws change, state, city, county laws change, and unless they're attending those law reviews, unless they're up to speed and engaging, everyone is, just because they're an attorney does not make them qualified in everything under the law. So that's just my little spiel about hiring the right professional, because it makes a difference.
I agree. It's so funny you mentioned that, because usually when I do seminars, I do say, don't go to a slash attorney. So a slash attorney, like someone who does DUI slash real estate slash family law slash civil litigation slash estate planning, right? If you come to me with a DUI, you're going straight to jail. Like, don't even bother. So why would you go to one of those attorneys for what I do? And for some reason, I don't know what the reason is. For some reason, I see this area where, a lot of people,
right. They say they do.
A lot of people are, right. Yeah. Right. Oh, my cousin who does criminal law in New Jersey wrote me a Maryland will. What? They're not even licensed here. And again, like you said, everybody does it, and I don't understand that outlook at all. So, yeah. Good point.
So, the right questions, make sure you're going to someone who's up to speed, because rules, laws, regulations all do change. Consult with your CPA. There's so much content you can watch on YouTube and online. And we really wanted to bring this session forward for you to really bring this incredibly important topic to mind as things happen unforeseeably, and you want to have the right individuals be pre-assigned and really delegate your wishes the way that you want them to be handled. That is my wish for you. And I know, Lindsey, you have been an incredible resource for us. Again, you are licensed in Virginia, Maryland, and DC. In our show notes, we're going to have a ton of information that leads back to you. And I know you speak tremendously about this topic, and we really appreciate your time. Is there anything else that you would like to close our session out with?
No, I mean, we obviously didn't want to overwhelm people. It's really easy in this area to give too much information and scare people away. But I think that our website, which I'm sure you'll put up as well, does a good job of, like, we have FAQs and questionnaires and what to do when a loved one dies, like just a lot of stuff like that. And I totally welcome people to just look at it and just kind of see what kind of questions should I ask the person I go to, things like that. I think it's a good resource.
And I know you and I worked really hard at creating containing the topics we were going to talk about in this session, because we absolutely have more to talk about than we could fit into one session. So I would absolutely invite you and love to have you back. I know again, it's taken us months to be able to put this together, and I appreciate you making time for us today. And I look forward to having you back for us to continue the dialogue and the conversation. To our listeners, please write in, email us, and let us know if you have additional questions and topics that you would like for us to enhance and talk further about on our next episodes, and as we invite Lindsey back for additional topics. Thank you so much, Lindsey, for your wonderful time today. It's been quite informative.
Thank you for having me, Anne.
Thank you so much, everyone. Tune in for our next show. We look forward to greeting you back here on Downsizing Your Home and Life Radio. Thank you so much. Bye-bye.